The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, ladies and gentlemen, and welcome to this afternoon's running of our webinar on the first steps towards GDPR compliance. My name is Alan Calder. I'm the founder of IT Governance. I'm going to be your speaker this afternoon. Before I go any further, I should tell you that this part of East England appears to be suffering ad hoc internet outages, so there might be the odd moment when I appear to go quiet. I will not necessarily be aware of that myself, so I'll be continuing going on with the webinar, and hopefully the totality of what I'm saying will be effectively recorded, and as is our normal practice anyway, the recording together with the slides will be available to all delegates on the webinar from sometime early next week. IT Governance is a company which I set up some 10 years ago to be a single source for everything to do with IT governance for data protection, cybersecurity, governance, risk and compliance generally, and the business has grown now so that we've become effectively a market leader in information security, particularly around ISO 27001, and of course in data protection, the EU General Data Protection Regulation. The webinar today is planned on about 45 to 50 minutes of me talking through the first steps towards compliance, and then there'll be a period of about 10 minutes available at the back end to handle any questions which you may have. And if you find yourself with questions through the course of this webinar, please do use the question function in the GoToWebinar panel, which should be up on your screen. Type your question into that as the question occurs to you, and then when we come to the Q&A section, what I'll do is I will read out the questions in the order which they have been posed so everybody knows what the question is, and then I'll share with you the answer that I have, and I'll get through as many of those as I can in the period left over for Q&A at the end of this webinar. Our program today is to have a look at the regulatory landscape and the territorial scope of the European Union's General Data Protection Regulation, its key principles, rules around breach notification, data subject rights. We'll look at changes to consent, which have a particularly significant impact, for instance, on the lawful basis for processing the data of employees. We'll look at liabilities of processors, particularly in relation to data controllers, each of which is now a term clearly defined in regulation. We'll look at the role of the data protection officer. We'll touch on international transfers and the role of supervisory authorities and how pan-European consistency is envisaged to come about. Before we start, it's worthwhile just rehearsing that there are two different types of European Union law, directives and regulations. They have different weights. A directive is a European Commission directive to member states. It tells them that they have to write a law, they have to pass a law in their own legal system that achieves a set of minimum objectives, and as long as those are achieved, it's up to the member state to embellish or extend or improve on those minimum objectives. The current data protection directive, which applies across the whole of the European Union, gave rise to the Data Protection Act 1998 in the United Kingdom and to different types of data protection legislation in the other 27 member states of the European Union. A regulation, on the other hand, is a law which, once passed by the European Commission through its fairly complex process for passing laws, becomes law exactly as written in every single member state. A number of such regulations will contain with them derogations which allow specific areas in which member states can do whatever they think is appropriate or necessary for their own circumstances, but outside of derogations, the law goes into force exactly as written in every single member state. It doesn't depend on enabling legislation by member states. It goes into force by virtue of the European Union treaties, and the European Union General Data Protection Regulation, rather, as its name suggests, is a regulation, and it applies across the European Union from the 25th of May 2017. It was passed on the 26th of May 2016. There's a 2-year transition period, of which there is now something like about 7 months left. Under the General Data Protection Regulation, the way the regulation works is that data subjects, that's you and me, we have rights, we own our own personal data, and we share that data with data controllers. Data controllers are organizations or entities. A data controller can obviously be a group of people. It can even be, under certain circumstances, a natural person collecting data for purposes other than purely domestic ones. So we share our data with data controllers. Data controllers might outsource some of that processing to a data processor, but won't necessarily. Data controllers quite often will do all of their processing themselves. And the way that works is subject to oversight by a supervisory authority in each member state. In the United Kingdom, that supervisory authority is the Information Commissioner's Office. Data controllers might move data outside of the country within which it was processed, either to another European Economic Area country or indeed to a country outside of the EEA, and there are specific requirements around how that is handled. And data might be shared with third parties or might indeed be captured by from third parties, but there's a complex set of relationships which GDPR requires to be clearly identified, and the rights of data subjects are therefore matched by duties of data controllers. The Information Commissioner's Office enforces and assesses compliance and therefore has the power to levy fines. And it's up to data controllers to make sure that data is processed with adequate levels of security, there are appropriate guarantees in place, and that there are appropriate disclosures about how data is going to be used and with whom it is shared. The European Data Protection Board is responsible for ensuring that all the 28 member state supervisory authorities interpret the law in a consistent way, and for ensuring that guidance and so on is shared properly across the whole of the GDPR ecosystem. So that's the data protection model under the General Data Protection Regulation. And the starting point is to say that natural persons have rights. A natural person is a living human being. Corporations are legal entities, they're not natural entities, so corporations don't have rights. But any individual working inside an organization, so Alan Calder at itgovernance.com, that would be personal information, it identifies me, and all such information is subject to GDPR. Any data which is capable of identifying a data subject and which is processed wholly or partly by automated means, or which is part of or meant to be part of a filing system. A Rolodex is a filing system. A pile of business cards in the corner of the desk or in your pocket is not a filing system. The first is going to be GDPR compliant. The pile of loose calling cards is not. GDPR says that data subjects are entitled to their personal data being protected, to its processing being protected, and to the unrestricted movement of their personal data within the European Union. But it reaches further than that. The territorial scope of GDPR is that it applies to all controllers and processors in the European Union, irrespective of where the processing takes place. So if you have an outsourced data processor in India or Canada, that's going to be in scope for GDPR. If you are a controller not in the European Union, but providing services either paid for or unpaid for into the European Union, you're caught within the territorial scope of GDPR. So GDPR is, to all intents and purposes, the first global data protection regulation. It affects controllers throughout the world if they're providing services into what is one of the world's biggest markets, and it catches any processing of data that moves outside of the European Union, and any entities which are dealing with that data are also caught by it. So that's the material and territorial scope of GDPR. In order to enforce it, supervisory authorities have the power to levy administrative fines. And there is a tariff set out in GDPR, which has two ceilings for what you might think of as being minor transgressions. The ceilings are up to 10 million euros or 2% of global turnover, whichever is the higher. And for major transgressions, and that's transgressions in and around areas related to the 6 data processing principles, to the rights of data subjects, and to international transfers, the fines can be up to 20 million euros or 4% of global turnover, again, whichever is the higher. It's important to recognize that fines have to be proportionate, they have to be effective, and they have to be dissuasive. By law, dissuasive we think means they have to hurt, but they also have to be proportionate to the size of the organization that's transgressed and to the size of the offense. And they have to take account, for instance, of the extent of negligence. An organization that, having done everything it possibly could, still suffers a breach might expect to have a very much smaller fine, if a fine at all, than an organization which has suffered a breach and has been negligent in its approach to how it meets its compliance obligations. So penalties are a significant issue, and for all organizations across the European Union, these penalties are significant. They can make a very real dent in corporate profits, and the fact that if you have multiple breaches over a period of time, could find yourself with multiple fines should make this an even more worrying set of circumstances. So what is a personal data breach? GDPR defines a personal data breach as any breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data transmitted, stored, or otherwise processed. So that means data at rest, data in flight, data in emails, data in email systems, data on databases, data in Excel spreadsheets, data anywhere is within the scope of GDPR, and a data breach is any compromise of confidentiality, integrity, or availability. So the fact that ransomware gets loose on a system and that none of the data is exposed, its integrity is not compromised, doesn't change the fact that there's been a data breach, because its availability was also compromised for the period during which the ransomware was in place. There is an obligation for a data processor who has to operate under a contract from a data controller to notify the data controller without undue delay after becoming aware of a breach. There are no exemptions. All breaches have to be reported to the data controller. The controller has an obligation to notify the supervisory authority. And that notification, again, is as soon as you're aware, or certainly not later than 72 hours. You have to provide quite a lot of information to the supervisory authority, including the nature of the breach, what you're doing about it. If you can't report within 72 hours, you have to explain why that is. And if there is a high risk to the rights and freedoms of the data subjects, then by law, you will have to tell the data subjects themselves, and also that without undue delay. So the data breach reporting obligations are significant. If you have, as Equifax did, a data breach, you will not be able to keep it secret for a number of months, not without a significant transgression of the law. And of course, significant transgressions are going to trigger higher levels of fines. As I said, the GDPR will apply from the 25th of May next year. We're about 7 months left to finish becoming compliant. And the important thing to note is that that's the date on which you have to be compliant. It's not the date after which you have to start complying. So any data which you're processing on the 25th of May next year needs to be processed at that point in line with GDPR. And that therefore means all the data which you've gathered over the years up till then needs to be compliant. If you're holding data you no longer got a lawful basis for holding, you need to remove it. If you don't have what GDPR will recognize as a lawful basis for processing, you need to get one in place. That's particularly important around the processing of data of employees. Most organizations will be processing employee data on the basis of consent, and that's not going to be a valid basis in future because of the unequal relationship between employer and employee. So when we get to look at consent briefly, you'll see there are alternatives, and you'll need to select one of those, and you'll need to have told all of your employees what you're doing. So you have to make sure you get compliant as quickly as you can. Remember that the regulation applies to data subjects irrespective of nationality or place of residence. So technically that could mean people who come onto your e-commerce website in the European Union, but themselves live in Canada, Asia, Malaysia, Venezuela, wherever it is. They're all entitled to the same level of protection, and they have the same rights as individuals, the same right to access information, the same rights to see their data protected, and so on. We'll look more at rights shortly. So in simple terms, Article 11 says the controller will take appropriate measures to provide any information that the data subject might want in relation to the processing in a concise, transparent, intelligible, and easily accessible form using clear and plain language. That means that what we currently call privacy policies, and would more properly be called a privacy notice under GDPR, can't anymore be written in complex legal terms. They have to be written in terms that enable a data subject to properly understand what it is that's happening with their data, and two, where you're relying on consent to it, and the description of what's happening has to be at a granular level. You will not any longer be able to bundle together 4 or 5 different purposes of processing and seek to have one mechanism for getting the agreement of the data subject. You'll need to break it down, and you quite possibly will need to have different lawful bases for each of those processings that are taking place. You also have to, as a controller, facilitate the exercise by data subjects of their rights. And their rights start with the right to information about what you're doing with their data, the right to access their data to find out what you're actually doing with it. Does that accord with what you said you were doing with it? The right to rectify or correct any processing which is incorrect, where you've got data wrong. The right to erasure. The right to erasure is not an absolute right. It is triggered by consent, brings the right to erasure, or what's called the right to be forgotten. The fact that data is no longer needed for the purposes for which it was collected would trigger a right to erasure. But as I said, it's not an absolute right. If there is an overriding alternative reason for processing, then you will continue processing the data, such as a statutory obligation to collect the data. Data subjects have a right to restrict your processing during the period that you might be arguing over its accuracy or the purpose of processing. The right to object to processing, where the lawful basis of processing is, for instance, legitimate reasons rather than consent. Where consent is the lawful basis, then they have a right at any time to withdraw consent, and at that point you'll have to stop processing. They also have a right to data portability. Again, not an absolute right. It depends on them having consented to the processing in the first place. So a lawful basis like statutory obligations would not trigger the right to data portability. Where the right is triggered, they have the right to get their personal data in a format which enables it to be transmitted to another provider at their wish. And finally, they have the right to be made aware of the existence of automated decision-making, including profiling, as well as the anticipated consequences of that profiling. So significant rights, and facilitating the exercise of those rights means they need to be included in your privacy notice, and it must be possible for the data subject on your website very easily to exercise those rights. Can't be hidden away, needs to be very upfront and transparent, and your processes need to ensure that you respond to the exercise of those rights. So I said it's the rights of data subjects which then trigger the duties of controllers, and controllers are those entities which determine the means and purpose of processing. And the 5th article of GDPR says that the controller is responsible for and must be able to demonstrate compliance with paragraph 1 of compliance 5. And paragraph 1 says the controller will be accountable for the processing of data which it collects. And accountable must mean from the board down. Accountable must mean that across the 6 data processing principles, the board and the organization will ensure that data is processed lawfully, fairly, and in a transparent manner. That's the first data processing principle. It needs to be clearly applied to all processing, that the data itself is collected for specified, explicit, and legitimate purposes. Legitimate is a legal term. There are a number of specified legitimate purposes. For direct marketing is a legitimate purpose. Tracking the behavior of people for security reasons is a legitimate purpose, and there are others. And frankly, if you can get clear what the specified, explicit, and legitimate purpose is, all the rest of the principles are much easier to apply because you'll know what you've collected the data for, and so you can determine what data exactly you need to have. The third principle, that it should be adequate, relevant to the purpose, and limited to what's necessary for the purpose. The data should be kept accurate where necessary in relation to the purpose. If you no longer need it for the purpose, then you should get rid of it. That's the fifth principle. Data should be retained only for as long as necessary. And the sixth principle, bearing in mind this is the data protection regulation, is that data should be processed in a manner that will maintain security. Breaches of any of those 6 data processing principles, remember, triggers fines under the higher tariff. That's up to 4% of global turnover. And the Information Commissioner in the UK set out clearly back in January of this year what she thought accountability meant. In a speech to the Institute of Chartered Accountants of England and Wales, what she said was that while the legislation creates an onus on companies to understand the risks that they create for others and to mitigate those risks, it's really about moving away from seeing the law as a box-ticking exercise and instead to work on a framework that builds a culture of privacy that pervades an entire organization. She went on to say that organizations have to put in place comprehensive but proportionate governance measures, and that means a change to the culture of an organization. Not easy to do, but accountability has to be embedded in the organization, has to become part of the company's overall systems approach to how it manages and processes personal data. And that means that when there is a breach and the Information Commissioner is investigating the breach, they'll be looking to see not just what happened, how did the breach occur, but they'll be looking to see very specifically what steps were taken to enable, what steps were taken by the organization to ensure that it met its compliance obligations, what we'll see called shortly data protection by design and by default. So applying the principle of accountability must start with board accountability. The corporate risk register should have an item on there identified as risks to the rights and freedoms of natural persons or data subjects. There should be a nominated responsible director. In fact, if you think of the way in which an organization responsible organization approaches its health and safety at work obligations, that's pretty much how you need to be thinking of approaching your GDPR obligations. Clear roles and responsibilities around the protection of data throughout the organization. That may well mean the mandatory appointment of a data protection officer, but not all organizations have to have a DPO. There are specific circumstances under which it's required, but frankly, most organizations are likely to need a DPO. The regulation is complex, the penalties and outcomes of non-compliance are significant, and a DPO can make a very substantial contribution to helping the organization meet its compliance obligations. You need to have a privacy compliance framework, which is made up of both a personal information management system, that's all of the documents that go around having a data protection policy, internal audit policies, and so on, that ensure that data is being managed the way it should be, and an information security management system, which ensures that you've got appropriate controls in place that are proportionate to the risks that you've identified to the data that you're gathering. You unquestionably need an incident response and data breach reporting mechanism, given that most organizations are going to be breached more than once in the course of a year. Being able to identify the fact that you've had a breach, respond effectively, determine centrally whether it's a significant breach that needs to be reported either to the supervisory authority or to the data subjects themselves is a key thing to do. Knowing that you have a reporting obligation, not putting in place a mechanism for reporting, I think is likely to be construed as negligent. There are minimum standards you should be thinking about. Cyber Essentials in the UK is certainly a minimum technical standard for cyber security. There will be the emergence over time of data seals around processes. ISO 27001 is a standard for information security management systems, an internationally recognized standard against which the information security management system can be assessed. And so those are logical components of any organization's privacy compliance framework. Organizations have to move towards data protection by design and by default. It's a regulatory requirement. Design and default starts with doing a data flow audit, looking at how data is collected, who has access to it, what happens to it, where it's processed, what inventories it's held in. All of that is an essential precursor to being able to work out whether the 6 data protection principles are correctly applied across those processes. And for many organizations, those processing high volumes of personal data or special categories of data, a data protection impact assessment is likely also to be mandatory. If it is mandatory, it's certainly a requirement to have the input of the data protection officer, and there are a number of other legal requirements around how the DPIA is performed and data collected. So let's talk a bit about lawfulness, and lawfulness will lead into the issue of consent. Article 6 of GDPR says that you have to have a lawful basis for processing personal data, and that's either consent or one of a number of alternatives. You should think of consent as being the option you use if one of the other alternatives cannot be applied, because consent brings with it a number of significant obligations, including the right to enable someone to withdraw consent, the right to erasure, the right to portability. So you want to have a look, for instance, at options like in order to deliver a contract that you've entered into with a data subject. That would be one of the lawful basis for processing the data of an employee. Statutory obligations, the legitimate interests of a controller, that would be why you track information about somebody's behaviors in terms of cybersecurity. So look at the alternatives they set out in Article 6. If none of them can genuinely be applied, then you go back to consent. Lawfulness also requires you to be clear about whether, in relation to this specific process, you're acting as a controller or a processor. Under the Data Protection Directive or Data Protection Act, you might have thought of the organization as, generally speaking, a data controller. You might have thought of the individual inside it as being a data controller. For GDPR, controller applies to the data, and it's entirely possible that one organization could be the data controller in respect of some data, such as your employees, but it could be a processor in relation to other data, such as if, for instance, you're a payroll company, the information about your clients' employees whose data you're processing pursuant to a contract with your clients. So you'll need to identify whether, in relation to each set of data, you're a controller or a processor, because that enables you to determine what your obligations are in respect of that data. A controller is the entity that determines the means and purposes of processing, and so it's a controller who determines whether or not data should be outsourced. Processors may only operate under a legally binding contract. So if you think you're a processor but you can't identify a controller with whom you have a contract for the processing of that data, then you're going to be a controller. And getting that relationship clear is an essential part, early part of a GDPR compliance project. Controllers are responsible for ensuring that the processing of data throughout the process, including as carried out by their contracted processors and potentially the processors' contracted sub-processors, are carried out in compliance with the GDPR and in compliance with the rights and freedoms of natural persons. So controllers have got a significant obligation, and controllers don't have the opportunity to say, well, the processor we chose was pretty rubbish. The fact that they've done a bad job is their fault, because you're the controller, you made the choice. And so you would expect the supervisory authority to focus on you, the controller, and your negligence in how you went about selecting a processor if there is a breach. So controller, very critical role, and the roles of controllers and process both clearly legally defined in GDPR. If you're relying on consent, there are a number of things you have to bear in mind. The first is that people under the age of 16, generally speaking, are not allowed to consent to the processing of their personal data for the purposes of online services. That doesn't affect anything else they may do, but it is an area under which member states have derogations. The UK has chosen to take the maximum derogation, which allows for children 13 years and over to give consent, but not under 13. Consent, if given, must be clear and affirmative, so you can't rely on consent by default. You can't say, please untick this box if you don't want to receive the data. It has to be on the basis that a a consent is positively given by ticking a box, by changing browser settings, or something equally obviously affirmative. Consent, once given, has to be capable of being withdrawn. It has to be as easy to withdraw consent as it was to give consent. And quite clearly, silence or inactivity does not constitute as consent. In fact, there's a requirement in GDPR that you should be able to demonstrate that if you're relying on consent, the consent was fairly given. And fairly given means there has to be no inequality between the parties. You have to not have bundled up multiple items for which you're seeking consent, knowing that a data subject will consent to one of them, but not three of them. There's a prohibition on processing special categories of data. Special categories of data, they're set out in Article 9 of GDPR. They include areas like race, ethnic origin, political beliefs, health information, and so on. It's prohibited, it's not lawful to process that data unless you can identify a specific exemption from the prohibition. And exemptions start with the explicit consent of the data subject. Explicit, you have to assume, means the data subject knows exactly what that processing is going to be, exactly what you're using it for, and of course the Article 9 exemption applies on the basis that you've already identified an Article 6 lawful basis. So for special categories of data, you have to have both a lawful basis and you have to have identified an exemption that enables you to process that special category of data. If you're a health club, for instance, you'll almost certainly be processing the data of data subjects, not just their name, address, and where they live, but you like to be collecting the data about their health in order to tell them what exercises they can do. That health data will be a special category of data. You'll need a lawful basis for doing it, and you'll need an exemption, which is likely to be the explicit consent of the data subject to process that data. Articles 12 to 18 deal with the idea of transparency, and while transparency has been notionally involved in data protection up till now, it's very explicit in GDPR. So all communications with data subjects have to be concise, transparent, and intelligible. You can't send somebody 5 pages of legalese telling them that sets out their rights. If they don't understand them, you will have failed the transparency test. So you have to be transparent about telling the data subject who you are, what you're doing with their data, the purposes of the processing, transparent about the lawful basis of processing, transparent in responding to any request to exercise rights, not least of which is the right to know what you're doing with the data subject's data. In fact, when a data subject asks what you're doing with their data, what's called a data subject access request, what used to be 40 days under the Data Protection Act is now reduced to a month that you've got to respond. You can no longer levy a £10 fee for doing so, and you need to provide as full an answer as possible. So, onerous in processing data. Certainly, getting rid of data you don't need to have right now is a smart thing to do because it reduces the workload when faced with a data subject access request, as many organizations will be shortly after the 25th of May. Data protection, Article 25 and those that follow says must be designed into data processing by default. That means that when you're designing a new system or a new process, you need to think about the data protection issues for natural persons. You need to make sure that you've considered an appropriate way to protect their data. You've considered in designing a new process each of the 6 data processing principles, obviously only for processes which involve personal data. Data protection impact assessments are mandatory under certain circumstances. They're mandatory where technologies and processes are likely to result in a high risk to the rights of data subjects. So it's high risk, and that means certainly where you're processing high volumes of data or processing data collected in a significant quantity in a public area. Part of your compliance program, therefore, needs to be a data audit. You need to know what data you've got. You need to go and have a look at what you've collected as well as what you're planning to collect in future. You need to make sure you've got a lawful basis for the data you have collected. You need to remove data that you don't. You need to protect data that you've currently got. You might need to put in place encryption and other mechanisms to protect data right now to ensure that by the time you get to May the 25th next year, you actually are in a position to demonstrate that you're protecting that data. Frankly, of course, compliance with the Data Protection Directive should mean that you are already protecting the data appropriately. We know that in the United Kingdom, large numbers of organizations are not actually that close to compliance. Article 32 and the ones that follow talk about the security of personal data. And there's obviously a link between Article 32 and Principle 6, Data Processing Principle 6. The sixth principle, as you know, says data must be processed in a manner that ensures the appropriate security against accidental loss, etc. And Article 32 requires controllers and processors to have a level of security appropriate to the risk. Appropriate to the risk isn't defined anywhere. And that means that you have to put in place a mechanism for doing information security risk assessments. The Information Security Risk Assessment Standard, ISO 27005, is one such appropriate standard that you can use, bearing in mind, though, that you need to be focusing on the rights and freedoms of data subjects, not just risks to the organization. So you need to have a mechanism for doing a risk assessment, for determining what the level of exposure is and what an appropriate control would be, and then in the light of that, to select and put in place appropriate controls. You'll need to have processes for the regular testing, assessing, and evaluation of the effectiveness of your controls and other security measures, because you'll want to make sure they are actually working. The fines are levied not because you had some controls, but because you had some controls and didn't make sure they were working. In other words, it's the reality of your negligence or otherwise that goes to the size of any penalties. We believe that certifications, Cyber Essentials, ISO 27001, will enable you to demonstrate, even if you are breached, that you were tackling your obligation to protect data in the best way you could. These are the Cyber Essentials, is a UK government recommended and created security standard, basic level security standard. ISO 27001 is the baseline security standard for organizations in terms of managing information security, including risks that arise through employees, third parties, and all of those areas. So the privacy compliance framework, which I talked about earlier on, is really a link between information security management, all of the privacy management system, documentation, the 6 data protection principles, and tying it into how as an organization you exercise your accountability for governance, risk management, and compliance. Some organizations, as I said, have an obligation to appoint a data protection officer. GDPR says that for organizations processing substantial volumes of personal data, and where that's a core part of the business, then the appointment of a DPO is mandatory. It's a protected position. The DPO will report directly to senior management. A DPO has to be appropriately qualified. They need to have a legal background, but they don't have to be a lawyer. They need to understand both the practical reality of data protection compliance as well as the legal requirements so that they can provide advice to the board. They need to report to senior management, and a DPO can be employed on a full-time basis. They can be employed on a part-time basis. They can be rented in. You can employ a DPO on a DPO as a service basis. All of those options are possible as long as the DPO is in a position to provide unbiased advice to the board. Outside of those organizations where there's a mandatory appointment, it's still a good practice appointment. As I said earlier, the reality of compliance is that it's a challenge, and so having somebody who genuinely understands how to help you get compliance is a sensible investment. Many other people inside the organization outside of a DPO need to know what's going on. HR, for instance, marketing, sales, they're all collecting personal data, so they need to have a basic understanding of the principles and the rules. Them collecting data that you don't know they're collecting will expose the organization, so you want them to understand, but you want them to understand in a way that doesn't get in the way of them doing their jobs effectively. The reality of GDPR is that you should be able to carry out your roles and responsibilities in a normal way without having to say, I can't do X, Y, and Z because of data protection. That's often a wrong interpretation of the requirements of the law. Staff awareness training is critical. Staff everywhere are going to be responsible for data protection in the sense that if a member of staff clicks on a phishing email, that might lead to the exposure of personal data. Somebody sending out an email to the whole of their database might expose personal information to those who are not entitled to see it. So training people, staff awareness training, typically done in some form of online e-learning staff awareness training, is also a pretty solid and significant part of effective data protection or GDPR compliance. I mentioned certifications briefly. It's possible to, in demonstrating that you're doing what GDPR says, which is apply appropriate administrative and organizational measures. How do you demonstrate that? You could demonstrate it, we believe, by Article 40's identification, Article 40 of GDPR, identification that certifications are a practical mechanism for organizations to demonstrate compliance with the GDPR, either complying with codes of conduct or with national or international standards, and ISO 27001 or BS 10,012 seem to be standards which meet those specific requirements. Of course, any certificate that you might have won't absolve the controller of its need to comply with the requirements of GDPR. So you're collecting data in the United Kingdom, you want to transfer it to a sister company in France, or you want to process it in Ireland. Technically, those are transfers beyond the country within which it's collected, but GDPR says that you can transfer data within the European Economic Area freely, so that's not a problem. You do, however, need to tell the data subjects what you're doing with their data. If you're not processing it in the country that it was collected, you need to explain where it's going to go and why. That's one of the decisions you as a controller make about the processing of the data. If you're moving it outside the European Economic Area, there are more significant issues. You either have to have an adequacy finding in respect of that country, so countries like Canada, a number of the small islands and dependencies all have adequacy findings. The United States does not, Australia does not, and in the absence of an adequacy finding, you need one of two other options. The first is that you might be an international company and you're moving data to a subsidiary outside of the EEA, in which case you can put in place something called binding corporate rules. BCRs have to be approved by the supervisory authority. They have to be, there's a model for them, but you have to develop them each time afresh. They have to be approved by the supervisory authority, and then as an international organization, you have to enforce them. Or if you are transferring data to a third party, not yourself, then you have to put in place what are called standard contract clauses. These are available from the supervisory authority, and you incorporate them as written. There's no room for amendment. You incorporate them as written into your processing contract with that third party. In the absence of any one of those three, you have a problem. There are some derogations which allow for unusual circumstances where data is being processed, but none of them are good enough really to rely on as a standard business basis. Some of them, as I say that, might be appropriate for travel companies making arrangements with small numbers of destinations where you might need to have some other arrangements. But broadly speaking, it's transfers on the basis of adequacy, transfers subject to appropriate safeguards such as standard contract clauses or the application of binding corporate rules. Cloud providers are a key risk area. Not all cloud providers are processing data or are based inside the European Economic Area. So as a minimum, you need to make sure you know where your cloud processors are based. You need to be able to tell them not to process data outside the EEA. The highest penalties, remember, apply to breaches of the trans-border processing requirements. In respect to the United States, there is no adequacy finding, nor is there likely to be, but it's a significant destination and a significant supplier of services. And the European Union has therefore put in place arrangements with the United States to provide a safe harbor for organizations who comply with its regulations. The previous model, what was called the Safe Harbor Framework, was found to be deficient in 2015. It was overthrown, found to be invalid. A new mechanism called the EU-US Privacy Shield was put in place in July 2016. It's just gone through its first review, and it's been decided by the European Commission that while it appears to be capable of some improvements, it's still valid and still working. And the EU-US Privacy Shield essentially means that US organizations that want to receive data from the EEA, from the European Union, can register under the Privacy Shield, and providing they give firm and binding commitments and meet a number of other requirements, are treated as though they're operating in a country that has an adequacy finding. So international transfer is a significant issue for organizations, particularly in today's cloud and internet-based economy. Supervisory authorities is how the GDPR is enforced. Every member state has a supervisory authority that has a number of tasks which include monitoring compliance, promoting awareness, communicating information, sharing best practice, but also enforcement. And those powers of investigation, correction, advice, and enforcement include the powers to levy fines. As an organization operating across multiple member states, you can select a lead supervisory authority with whom you deal in respect of all of your processing across the European Union. That can make processing much simpler. For organizations inside the United Kingdom, there is as yet no certainty that beyond Brexit there will be a finding of adequacy in respect of the United Kingdom, and selecting the Information Commissioner as a lead supervisory authority is potentially problematic because, as GDPR is written, a lead supervisory authority has to be selected from a member state of the European Union. So yes, you can select the ICO now, but beyond Brexit it's likely to be an implication. So those are two areas that organizations processing across the European Union fault line have to pay careful attention to over the evolution of Brexit. Finally, the enforcement is, as you've seen, through European Data Protection Board, whose job it is to ensure that supervisory authorities operate in a consistent way. It's not a super regulator, it's simply a consistency mechanism. It can deal with questions arising, provide advice to the European Commission, give firm rulings on contentious subjects to supervisory authorities. It's there to ensure correct application of the regulation. And at the moment, Working Party 29, which was responsible for creating GDPR and is currently developing guidance on a number of areas, is going to become the European Data Protection Board later on this year. So the Information Commissioner, in final words, says accountability, yes, requires money. If you can see the benefits that accountability brings to your organization, you'll get on with it right now. That's a good thing to be doing. For those who don't really believe in protecting the privacy of individuals, then you have to bear in mind that accountability also means that we have a big stick that we could use to ensure that you're doing what you should be doing. And in the last paragraph of her speech, she said, do bear in mind that we aren't going to use our enforcement powers just around typical breaches. We're going to be using them because of failures in terms of accountability, failures in terms of data protection by design, failure to conduct DPIAs, inadequate DPOs, inadequate documentation, all of the core stuff which you should put in place to demonstrate that data protection is a cornerstone of your business practices. So what do you do? How do you get yourself compliant? There are 9 steps to GDPR compliance. Starts with creating a governance framework, a risk register, a proper accountability framework, appoint and train a data protection officer, somebody to provide proper advice to the organization on what it's doing, do a data inventory, work out what personal data you're processing, find out with whom you've contracted by either where you're a processor or where you're the controller and you've contracted with a processor, make sure you've got appropriate contracts in place, identify any data you're holding that you no longer have a lawful basis to hold and purge it. You should have done that anyway. Do a data flow audit, analyze the data flows, work out how the 6 data protection principles are applied, if they are at all, and that will drive your first major remediation plan. In other words, the compliance gap analysis, both at the individual process level, but also at the organizational level. Make sure you put in place a data subject access request process. You've got records of processing to meet the requirements of Article 30, and then drive your data protection impact assessment around core processes, do the analysis of security there, and remediate. Build a privacy compliance framework, look at things like Cyber Essentials and ISO 27001 as mechanisms to give yourself as a management assurance that data protection by default is in place, but also to demonstrate to the regulator that you've taken appropriate steps. Test your incident reporting and data breach response processes. You're going to be breached. You should make sure you know how to identify breaches and you can deal with them, and monitor, audit, and continually improve your privacy compliance framework. Do bear in mind that you can address all of those at the same time. From IT governance, there are a number of self-help materials. There's a pocket guide and a manual. There's a gap assessment tool, which an experienced user can use. There's a set of documents available in a GDPR ready documentation toolkit. There is a range of training courses, a one-day foundation and a four-day practitioner course available through the classroom, online, or through distance learning. There's a data protection impact assessment workshop. And of course, there's a substantial range of consultancy services available, including gap analysis, the thing we're doing most of right now, data flow audits. You can acquire data protection officer as a service, help implementing a BS 10012 personal information management system, implementing an ISO 27001 information security management system, and just a straightforward cyber health check to identify where your weaknesses and vulnerabilities are around cyber security. And that, ladies and gentlemen, brings me to an end in terms of what I was planning to say. There are some 8 or 9 minutes left for us to deal with questions. If you haven't already, if I can just remind you, please type questions into the questions box in the GoToWebinar control panel. What I'm going to do is go through as many of those questions as I can in the time that there is. I'm going to read out the questions. You can still add more questions. I'm going to read out the question, then I'm going to tell you what the answer is, and I'll get through as many as I can in the time that there is. So what happens when the subject is deceased? At the point that someone is deceased, they no longer have rights. The definition of a natural person is a living person, so dead people don't have rights. Any information about them is completely unprotected. Of course, heirs, beneficiaries, executors, they're all living people, so they do have rights. Do make sure those two are kept clear. Apology about the volume of information in a short space of time. The slides and the recording will be available, so you'll be able to review it at your leisure and over several attempts. Article 33. In regards to the data breach on GDPR, is this only focused on personal information or any type of data? And the answer is GDPR is only dealing with personal data, so it only requires you to report personal data breaches. If you have a breach of a set of intellectual property data, you don't have to report that under GDPR. You might want to report the theft, but it's not a data protection regulation breach. Any personal data, and that includes obviously payment card data, is covered by this article. We're an international development organization which processes open source data, sometimes down to the village level, potentially identifying an individual. Would this be subject to GDPR? Yes, it would. You can identify people. If you're in the European Union, you're subject to GDPR, and GDPR says data subjects irrespective of place of residence or nationality. My organization is currently ISO 27001 certified. How big is the gap between that and being GDPR compliant? What are the recommended next steps? ISO 27001 is part of a solution. It's looking at information security. The other two parts of the solution are the privacy, the personal information management system, so data protection policies, identifying what personal data you've got, applying the security controls to protecting personal data, and the governance framework, the accountability and governance framework. So I would tackle in terms of the number of steps we've got there, all of the other steps other than the information security management system one. I'm a telemarketing company. How is GDPR going to affect you? Well, if you're marketing to people, it's going to affect you. The fact that you're phoning business contacts doesn't change anything. A business contact is a human, therefore their data is protected, so you need to have a lawful basis for processing that data. The lawful basis might be consent. I can see no reason why, if the data is available in a telephone book, you shouldn't phone somebody up and say, hi, this is where I got your information from, may I talk to you? This is what consent means. If you've collected the data from somewhere else that you're using, technically you should send them a privacy notice before using that data. Will small charities need to fully comply? Will they be excluded? There's no specific exemption for charities. There is a derogation that says that the requirements around documentation, for instance, are reduced where organizations can identify, organizations with 250 or less employees can demonstrate that there is no risk to the rights and freedoms of data subjects. I'm not, I have to say, clear how any organization can demonstrate there is no risk other than saying that all data is encrypted and similar mechanisms to protect the data. But there is a derogation which says you can reduce the documentation requirements, but otherwise you are still covered by GDPR. Ray, consent for opt-in of email addresses, does this apply to registration cards? I.e. you need to have to create a ticket box on a registration card if we wanted to use their email addresses. However you're doing this, for whatever purposes, you need to say, I want to collect your data to do this and this with. If you want to use it for two different things, two different emails, which have different purposes, as is most likely the case, then yes, you should ask permission for each of them separately. You shouldn't be saying, we'd like your permission to send you a range of different emails or newsletters that we'd like to send you at any one time, because that would be bundling consents. It's not sufficiently granular to be transparent. Is a controller an individual in an organization? No. The organization is the controller, and it will identify or nominate roles and responsibilities inside the organization. And the organization will be a controller in respect of some processing and a processor in respect of other processing. Could you give an example of how a small business with two directors who operate a web design agency could be at risk with GDPR? Yes, of course. Two directors, if you have any employees, they're entitled, if, for instance, they discover that you've been processing their data without their permission, to bring an action. They can bring an action in a law court for non-material damage. They can seek financial compensation for which there is no ceiling for non-material damages. So I've discovered that you've been processing my data for the last 10 years. You didn't have my permission. I'm so upset. I'm signed off work and I need you to give me £10,000 to feel okay. That's entirely possible. You could have a breach because the customer's data that you've collected, or your customers, you're doing digital design for a range of customers, that the customer data you've collected is breached, as a result of which you're investigated, and the investigation finds that you're not compliant, as a result of which you get a fine. Any one of those are possible ways in which you could find yourself at risk with GDPR. If employees don't consent, then they're not able to use cashless catering. Well, the issue of consent is pretty critical. You will not be able to rely on consent as a valid basis for processing employee data, because the relationship between employer and employee is one of imbalance. The employee is too powerful. However, there may be services such as the provision of luncheon vouchers, which is not a requirement of being an employer, which you might offer to employees. And you might say that to employees, if you wish to use the service, you need to consent to the processing of data specifically in relation to the service. You can withdraw consent at any time, and at that point, obviously, you'll no longer get the vouchers. That's a perfectly reasonable thing to do. The benchmark of consent is set out by the Information Commissioner in the UK. She's published very clear and detailed guidance on the use of consent. It includes a wide range of a number of examples as to how it works. So if you go onto the Information Commissioner's website, look under GDPR and look for guidance on consent, you'll get some very detailed guidance. Consent applies to under 16. So the UK has chosen, and it depends on the passage of the UK's data protection bill through the House, to go for the derogation taking the age of consent down to 13. But whatever is the case, anybody under the age set by law will not be able to consent to the processing of their data for information age services. That means that it doesn't stop them consenting to the processing of their data for any other lawful purpose, just for information age services. And that means that you will need to have a working mechanism for confirming that the person giving consent is in a proper position to give consent on behalf of the minor. Ladies and gentlemen, we're just about out of time. I'm going to answer just one more question, and then I'm afraid we're done for today. If I ask a person for their email address and if it is okay to send information, does this constitute consent? Nearly. If you ask a person for their email address in order to do a particular thing, I want to send you this information, may I do that? And they say, yes, here's my email address, that's consent to do that. But you'll need to do more than that. And I would suggest, along with it, you send them a privacy notice, one set out under Article 13 of GDPR, which says, this is what else I will do with your data, not just send you stuff. This is how long I will keep it. This is how you can exercise your rights in respect of withdrawal of consent, your rights in respect to rectification, objection, all of those kind of things, set those out in an Article 13 privacy notice. I would do that as well. Ladies and gentlemen, I'm afraid that brings us to the end of the allocated time. I'd like to say thank you very much for joining us. There are a number of questions here which I know would like to be answered. Some of them may already have been answered in the FAQs that we publish on our website. Please do take advantage of those. We'll try and get as many of these questions as we can answered by our in-house team over the course of the next week or 10 days, and we'll try and make those answers available as well through our FAQs. But ladies and gentlemen, thank you very much for joining this webinar. There will be more of these first steps to GDPR webinars over the months ahead. We know there are many organizations just starting out on their GDPR compliance program now. There are also specialist GDPR webinars dealing with specialist subjects, and you can read more about those on our website. Thank you for being with us, and have a good rest of today and of this week. Goodbye.